Hello and welcome to the FedNexus Law Government Contracts Industry Report for the week of October 20th. I'm Jennifer Aubel. In this week's episode, we'll be talking to partner Eric Crusius about the recent GAO decision to sustain a protest of an award of a $210 million DHS contract to embattled contractor USIS. We'll also discuss a recent GSA OIG report confirming that contractor teaming arrangements among GSA scheduled contract holders are poorly understood by contracting officers at the task order level. But before we get to those stories, here are a couple of the big headlines from federal contract news this week. First, the Bureau of Labor Statistics announced today a 1.7% cost of living increase that will begin on January 1st and apply to Social Security, federal, and military retirees. In other news, the first protests have been filed with GAO against the recent SEWP V contract award. 4 contractors have protested the awards, including a previous incumbent on SEWP IV, Unicom. Other protesters include BAFed, NCS, and KPOL. Now I'm excited to welcome Eric Crusius, partner at FedNexus, into the studio today, and he's going to be talking to us about a recent GAO protest that was sustained against USIS. So, Eric, why don't you give us a little bit of background on this bid protest?
This is pretty interesting. It's actually the latest in a parade of horribles, unfortunately, for USIS. USCIS is, of course, as most people know, is that contractor that did the background check on Edward Snowden, and since that time has had a difficult time with contract awards, and they had a cybersecurity breach. In fact, the Justice Department filed a lawsuit against USIS in January where it accused of the company of delivering at least more than 600,000 background investigations over a 4-year period that didn't undergo their required initial quality reviews and cut corners and things like that. So, contractor who was not awarded a contract, FCI Federal, filed a protest against an award that USIS recently won. $210 million contract, not small potatoes.
No, definitely not.
And FCI Federal essentially said that USIS can't be a responsible contractor based on all these things that have happened to them. This Justice Department lawsuit, OPM didn't renew a contract for USIS worth $2.45 billion that was awarded in 2011, and another contract worth almost $300 million. So USIS, then, their credibility and as far as whether they could be considered a responsible contractor is being called into question. GAO has not issued the decision yet. They've announced that they've issued a decision, and what's happened is it's under a protective order at GAO, meaning that only the lawyers involved in the case can see it. And the lawyers, I'm sure, as we do all the time with our protests, are haggling over redactions, what should be redacted, what shouldn't be redacted. And as soon as everyone agrees on the redactions, the actual decision will be released. In lieu of that, GAO did issue a press release about the decision because I thought there'd be a lot of interest in this. And the fact that the Wall Street Journal picked this up demonstrates that, besides all the local area news outlets that usually pick these things up.
Right, of course.
But GAO had some interesting things to say in their press release, and I'm just quoting from their press release. GAO sustained FCI Federal's protest after concluding that DHS's affirmative determination of USIS's responsibility was not reasonable because the agency failed to consider pending allegations of fraud by the awardee's parent company under another federal contract. An affirmative determination of responsibility is a legal term that describes the threshold finding inherent in the award of every federal contract that the company awarded the contract has the capacity, ability, and requisite integrity to perform a government contract. Now, as you can see from this press release, it doesn't mean that USIS is going to lose the contract. It just means that the agency has to go back and consider whether those fraud allegations by the parent company are enough to knock it out of the box as far as being responsible.
Well, do you think that the GAO is basically declaring an open season on protests against USIS and basically saying anyone can come through and say, you guys aren't responsible?
You know, Jennifer, that's a really interesting observation. I hadn't thought about that, but in a lot of ways, yes. The only way that USIS will be protected now in any of their proposals, and when there's a consideration of that proposal, is if the agency affirmatively states, we understand that these are allegations that are out there, we have evaluated them and found that that does not make USIS a not responsible contractor. But even then, you could see a contractor saying, well, that decision was unreasonable by the agency. So, I think open seasons are probably a pretty good way to describe it. But this doesn't mean that USIS will lose the contract. It just means, like I said, the agency has to go back, look at it, and see. Now, for their part, USIS has promised to fight this. And if you
I would imagine so, because if they lose the contract, it seems like this could just be the beginning of just kick them when they're down.
Yeah.
How are they going to ever win another contract?
It's probably not a good day in USIS headquarters right now. But USIS, for their part, has said, hey, the entity that's undergoing all this investigation is actually not the entity that was bidding for the work. It's the parent company of the entity bidding for work, and you shouldn't judge the subsidiary by what the parent's doing or accused of doing.
How does that work with affiliation when you have a responsibility determination?
It's a really good question, and it really just depends on a lot of factual circumstances about how closely tied these companies are. We don't know a whole lot as far as how they're tied. Of course, USIS is essentially saying that there's no relationship, and their professional services division, as they call it, that subsidiary is not party to the Justice Department lawsuit, so they're clean, and they should have never been swept up in this. And now that you have a protest upholding the contract, there's a number of things that can happen. One, an agency does not have to follow a GAO decision. It's a recommendation. Now, 99% of the time, they will follow it, because if they don't, they have to report to Congress that they're not following it, and agencies are unwilling to do it. And this is such a hot button. There's no way they're not going to follow it.
USIS is certainly not on everyone's favorite person's
list.
Yeah, it's Christmas card list. Exactly.
So prior to GHS even confirming that they're going to follow the decision, USIS has the option of moving to reconsider the GAO decision. They have 10 days from the actual decision date to do that, which it looks like from all these articles was maybe Friday, although it's unclear. It could have been as late as Monday. But they have 10 days to do that. I could tell you from personal experience and from anecdotal experience that motions for reconsideration are almost never granted. And
right.
So that is just kind of an endgame. There is one other procedural option they have. Once DHS confirms to USIS that they're going to follow the GAO decision, USIS has the option of going to the Court of Federal Claims and filing a lawsuit against the agency. And essentially they'd allege that the fact that the agency is abiding by the GAO decision is unreasonable and without merit. And we've actually prevailed on that before. This looks like a little tougher road to hoe. I mean, it's possible.
Yeah.
Their argument, they may have already showed their cards that what they'd say at Court of Federal Claims by saying, look, we're not the same entity. Why are you blaming us for, my friend over there,
Right.
So, of course, they're more than friends. So I could see this is a big enough award, and they're desperate enough at this time, whether it's their fault or not, to actually go to the Court of Federal Claims. And there's no particular deadline for doing that. And when they go to the Court of Federal Claims, unlike GAO, they have to apply for a stay. They don't just get it. So they have to essentially upfront show the court why they should win this case. And and there's a 4-prong test, but the most important prong is likelihood of success in the merits. So USIS has to demonstrate upfront in their initial papers that they are likely to succeed in challenging. It's done in a very gentle, roundabout way, but they're essentially challenging the GAO decision.
Right.
Because there's no direct appeal from GAO to the Court of Federal Claims, but this is a roundabout way that you could essentially appeal GAO decisions. And like I said, we've had success doing that sometimes, although we just try to reserve it for the cases that we think are, the most egregious, so to speak.
Yeah, well, because Court of Federal Claims doesn't have the same kind of time limitations in terms of filing as GAO, correct?
That's correct, yeah. The Court of Federal Claims has essentially no time limitation. Now, if you wait too long, the court will essentially say you sat on your rights too long and we're not going to entertain this. It's moot, meaning that the wrong that you're alleging is already passed. There's nothing we could do about it. Or they'll say there's a term called latches, a term that means that you've waited too long and you sat on your rights too long. So, but the court doesn't actually have a timeline. But if I'm USIS, of course, and I'm applying for a stay, I'm going to go as fast as possible on that.
Right. So do you think that USIS would go to COFC, or Court of Federal Claims, regardless of whether or not the award was reversed, or do you think they would reserve it?
So the motion for reconsideration at GAO, they have 10 days to file, but GAO has some time to review it and decide on it. So USIS will probably, my guess is what they would do is not actually file a motion for reconsideration, but instead just go straight to the Court of Federal Claims. Because if they file a suit in the Court of Federal Claims, GAO will probably say, we're not going to consider this now because you're at the Court of Federal Claims. So they're just wasting time and money, I think, unless their end game is just a GAO and they don't have any plan to go to Court of Federal Claims. But if they want to have any chance of getting a stay and doing something about this decision, they really just need to go, at least from what I'm seeing from the articles at least, go straight to the court.
It'll be interesting to continue to follow this story because it certainly has gotten a lot of media attention. I know I saw it all over my Twitter when the decision was announced. So
yeah, and I heard you talking about the SEWP V protests earlier, and that'll be interesting to follow also. So I look forward. I'll be happy to update the radio show on the USIS stuff, and I'll have a lookout for the SEWP V protests also, as I know Jennifer will, too.
Definitely.
So, Jennifer, I had an interesting time reading your blog on contractor teaming arrangements. It's pretty thorough, and I know you've talked about it before, but now that you've expanded on your thoughts in this week's blog, I was wondering if you'd have anything more to say about it.
Well, it's an interesting topic because contractor teaming arrangements are something that GSA really tries to sell to the contract holders. So, for example, this week I was helping a client with a contractor assistance visit, and the analyst conducting the visit was basically going, oh, so do you know about contractor teaming arrangements? Are you doing any contractor teaming arrangements? Don't you want to do contractor teaming arrangements? So GSA sells this really hard, and the reason is that when you have a contractor teaming arrangement, it allows multiple schedule holders to essentially glue their contracts together and both act as primes. So you're avoiding going into a prime sub situation. And the general reason that GSA wants you to do this is to try to avoid having open market items on the order.
Right.
So it allows people to bid for things they might not generally be eligible for because it's got a scope that's kind of beyond what their area of expertise is. But the interesting thing about it is that GSA really promotes contractor teaming arrangements, but then they say, but we're not going to tell you how to write the agreement. We will not vet the agreement for you. Just because you submit the agreement and the contract gets awarded, don't feel like your agreement has been blessed by the agency. And so they kind of like disavow all responsibility for the actual teaming arrangement. And what was interesting about the OIG report is that it was looking at it from the other side. It was looking at it from the ordering agency side. So they looked specifically at GSA's Assisted Acquisition Service, which does a lot of procurements for federal agencies for a fee. Because it's GSA, they like to use the schedules.
Right,
you know, they're going to keep it in house, right? So
you can almost get the double fee then.
Right, they can get the IFF, they can get their, procurement fee. Everyone's happy. But you would think that these are the people that would understand better than anyone how to use a contractor teaming arrangement, how to recognize one. And what they found is that they went through about a 2-year period of orders, and the Assisted Acquisition Service came back and said, okay, here are 11 orders that we found that have teaming arrangements. And then they found that of those 11, actually only like 6 or 7 of them actually were contractor teaming arrangements, and that the Assisted Acquisition Service had misidentified 5 task orders as having a teaming arrangement when they didn't. It just shows that there's not a whole lot of understanding about what these teaming arrangements are, especially because you need to recognize that they're not the same thing as the FAR 9.6 contractor teaming arrangement. They're totally different things. The other part that was kind of concerning for contractors was that the government acquisition systems don't have any way to basically input all the members of the team into the system.
Oh, gosh.
So they can only put the team leader. And what that means is that, and they do it for the administrative convenience of the order, so that they don't have to put out 5 different orders. They just give it to the team leader.
Right.
But they're not doing the appropriate excluded parties checks because they only have the one contractor in the system. So they're not vetting any of the team members. And additionally, it puts in a kind of an additional risk onto the team leader because all the past performance evaluation will go against the team leader regardless of whether they performed it or not. So just an interesting read to give you some ideas about if you're going to do a contractor teaming arrangement, what are some of the risks that you could encounter as a contractor, and what do agencies need to start doing? So they're saying they're going to put out some instructive guidance and they're going to make some changes to the regs, January 2016. So, let's not hold our breath. But,
right. That's already like 14 months off.
Yeah. So it's an ongoing issue, but we'll see what happens. So. And we'll keep everyone up to date.
Great. Yeah, I look forward to reading another blog about this and hearing about it on the radio show.
Yep. So, well, that's going to wrap it up for us today, and we'll talk to you guys next week here on the Government Contracts Industry Report.